Hello, today we are going to be going over chapter 3 of your book, Medical, Legal, and Ethical Issues. Let's stop this, it didn't work. Okay, sorry about that. It was a little bit of technical difficulties. Let me make sure it's going to work. Okay, so today we're going to discuss medical, legal, and ethical issues when it comes to EMS. So the basic principle of emergency care is to do no further harm. Also, a healthcare provider usually can avoid legal. Sorry, guys, this is really weird being on video. You can usually avoid legal exposure if you act in good faith, and if you, according to your appropriate standard of care. An appropriate standard of care would be what is within your licensure to do and what is generally done in the EMS world for that particular type of call. So that's why we have protocols. Protocols guide that. So if you were to get in, be drawn into a legal battle, then you would be able to say, well, this is what, this is our protocol, this is what we do, and that is a normal standard of care. Also, part of your job is providing competent emergency medical care that doesn't exceed your scope of practice. And your scope of practice is what you are licensed to do. And every licensure has a different scope of practice along with your protocols. They also guide that too. But a person has to give consent to be treated as well. So you want to make sure that you avoid any civil cases. You don't want any civil, any civil case of actions against you, criminal actions. So, like I said, with your normal standard of care. So the consent is permission, of course, to treat. And there's going to be different types of consent. One would be informed consent. Informed consent is when the patient is alert and oriented, able to make decisions on their own, and they are informed of what could happen to them if they do not get transported. So you always have to make sure that they know exactly what you're going to do and how it would affect them if you don't do it. So, for instance, if they want to refuse transport, then you would want to explain what the danger of them refusing transport would be. So whenever you try to decide if they are able to give their own consent, you have to look at their intellectual capacity. You have to look at are they impaired by medical or mental limitations. Dementia is really famous in the elderly people. They are not usually their own decision makers. Usually they have a DPOA, which is a durable power of attorney, which they make their decisions because they are considered incapable of making those decisions. You also want to make sure is the patient of legal age. All right, we're not really staying very good with the slides, but I can't see the slides, so it's hard for me to make sure I'm staying with them. So do they have any kind of barriers? We talked about this in class last night. Do they have any barriers, language barriers, those kind of things that would make them not be able to make their own decisions? I'm going to kind of turn here a little bit so that I can look and I can see to make sure I'm staying with the slides. So anyway, the EMT must explain the treatment, the risks, and the benefits of doing that treatment. And so that is considered an informed decision if they are told everything and they can make an informed decision. This implied consent applies to patients that are not, that are unresponsive, unconscious, they're unable to make an informed decision. So that's usually used when there is a threat to a life or limb. So say they are, you come up on a car accident and they are unconscious, they are hurt very bad, that's implied consent because they're not alert to be able to give consent. Um, so involuntary consent can be done by those that are mentally ill. So, or if they're in a behavioral crisis, say that they're suicidal. Those are common ones. They get 96-hour holds put on them um, by the judge, and that's how. Then we have to take them wherever the judge says to take them. Or they could be developmentally delayed. That makes a difference as well. You can also get consent from a guardian. So, like for someone that it doesn't have any family, that could be the public administrator. They could be their guardian. They could be a ward of the state, those kind of things. So then when they're a ward of the state, they're given a guardian that makes the decisions for them. It's not always possible to use your local protocol or and to understand local provisions, and you want to make sure it's not always where you can get this consent from the guardian. So you may have to use law enforcement or whatever means that you need to be able to take care of the patient. So minors in consent, the parents or legal guardian can give consent for them. In some states, minors can give their own consent. And in Missouri, it's when they're emancipated, and that has to be done through the court in order for them to be able to do that. Except if there is a young woman or young child that has a baby, while they're pregnant, they can be nobody can make decisions for them while they're pregnant, and then once their child is born, they are, of course, the guardian of the baby. So, so if there's no parents available, teacher officials and school officials can make decisions for the students, like we were talking about last night in class about the school bus crashes. School bus crashes that they're not real happy about it, but they can make, like the school bus driver or the principal or the superintendent, they can make decisions for them. But generally, in that kind of a situation, you're going to most likely be under the implied consent because they're going to be hurt or something, because you can get verbal consent from the parents generally. We also use forcible restraints. This is as we discussed about documentation last night, this is really, really important that this is documented, why you use the forcible restraints. But it's necessary sometimes with combative patients. And then also, you need to get law enforcement involved. If you're going to have to restrain somebody, it's usually a good idea to have them. One thing that I will say as a caveat to that is if law enforcement wants to handcuff your patient, they have to ride in the ambulance with you. Otherwise, it's kidnapping. So you don't want to do that. You cannot have, and if there is an accident, and they're handcuffed to the cot, and it's just, you're opening up a big can of worms if you do that. It is highly against our protocols and our rules here that you do not transport a patient that's handcuffed unless the deputy, the police officer, whoever, unless law enforcement is willing to ride along with you. So you do have a right to refuse treatment, but that has to be done by like a conscious and alert adult. They have to be able to, they have to have a good decision-making capacity at that time. So if they're not altered or they're not, anything like that, they can say, I don't want to be transported. I ran a wreck that a gentleman had a bone sticking out of his arm, but he was perfectly capable of making his own sound decisions. But because he was afraid they were going to do surgery, and even though he had sleeves of tattoos on his arm, he said he was afraid of needles and surgery. He was able to refuse. You can't say no, because then again, you're going into the kidnapping thing if you take them against their will. But if they are confused or if they're suicidal, delusional, you have to assume that they don't understand the risks of not going with you. So anytime that you have somebody that wants to refuse treatment, a parental guardian, whatever, you want to make sure that you stress more than one time and you document more than one time that you explain the risks to them of refusing, but they still chose to refuse. And then you get an AMA, which is against medical advice, refusal from them. You want to make sure that, like I said, that they sign the refusal form, but you also want a witness to that. And you don't want it to be one of the EMS people. You would want law enforcement, or if there's anybody else on scene, fire, somebody else to sign it. Generally, when we have something like this, it seems like that law enforcement is there, and they're generally perfectly willing to sign that refusal with you. So your protected health information, or PHI, that's what you'll hear it called a lot. That's their patient's history, your assessments, your findings, whatever, your treatments. And the only way that this information can be disclosed is if they sign a release. So, or if you have a legal subpoena, which it happens a lot for especially drunk people, things like that, or if it's needed by billing personnel, which that, I mean, the only time that PHI is able to be shared is in those instances that I just said. And for the continuum of care, payment is, so it's TPO, treatment, payment, and operations. So you can use it for training if you need to, but you have to de-identify it by taking anything that would identify that person off of that report. So that's part of the Health Insurance Portability and Accountability Act, or HIPAA. This was founded in 1996. It contains a special section on patient privacy, and that's the biggest part of the HIPAA that we deal with. So what it did was it strengthened the privacy laws, but it also confused places to where they were a little tighter with the information than they needed to be. Hospitals will tell us that they can't give us information because it is HIPAA, but it's not, because it's for continuum of care. But it does help. It does help safeguard their confidentiality, though. For example, when you run a call, it happens that people sit around and talk about it, but you really aren't supposed to use their names. You can learn from that, say, hey, what could I have done better? What, between you and the crew. But when you get the whole station involved, then that's really not, I mean, we do it, it does happen, but you just don't want to let somebody be in the room, somebody that wouldn't know what you were already, who you were already talking about. All right, a do not resuscitate order. A do not resuscitate order is a pre-hospital form. We have them in the truck if they don't have one and they want one signed, but these are generally signed by the patient or their guardian. It has to be signed by a doctor and dated. It can be revoked if they so choose. But a do not resuscitate order only means if their heart stops, we do not resuscitate. It does not mean we don't treat. We've ran into that before where people think that, okay, so they're a DNR and they're choking on something. Well, they don't do anything. Well, that's not okay, because that's do not treat, which there are such a thing as do not treats. But a DNR, it will state their medical history, their medical problems. And like I said, it will have those signatures. It also will have, can have an expiration date on it. Not all of them do, but some do. So, and an advance directive is a little bit similar to that, except for what it does is you can say what you want to have done if something happens and they follow those orders, because it will have their decision, it will have their signature on it. Then there's one thing that I will say. When you decide those kind of things for yourself, or you're thinking about a patient and you're trying to help them, consider what it really says, because I do know that when many years ago my father was taken to the hospital and he had an advance directive, and it just said that he didn't want any crazy life-sustaining procedures done, but he had emphysema really bad and he couldn't breathe, and he wanted to be intubated and just to get some relief and be able to breathe, and the hospital up here told him no because he had a DNR. he no longer had an advance directive after that, because then what we will talk about next is a durable power of attorney, because he wanted somebody to speak for him and be his advocate. There are also physician orders for life-sustaining treatment, and then medical orders for life-sustaining treatments as well. So what it does is they list on there the acceptable treatments that they would want. If they would want a ventilator, if they want, CPR, those kind of things. You have to really read those papers really good, because the state color for ours is purple, but the veterans home also has a purple form, and on the top it says, I do want to be resuscitated. I don't want to be resuscitated. And you have to be very careful with those and make sure that you read them properly and that they're all done correctly, because it's a legal issue. And then, like I said, the durable power of attorney is somebody that they have as their healthcare proxy, and they have them speaking for them on their behalf of what they want. That's where, they shared it with a family member, what kind of things they do and don't want. And always remember that a family member can say, do everything because I don't agree with this DNR, and you have to do it. So presumptive signs of death. I mean, we all kind of figure we know what that is, but so there are some key ones. You have unresponsiveness of painful stimuli. So in other words, if you do a sternum rub and they don't respond, well, then that's what that's talking about. They're not responsive to painful stimuli. If they have no carotid pulse or heartbeat, of course. Now, sometimes you can check a radial pulse and they don't have one, but if you check their carotid in their neck, they will have one. So that makes a difference too. Then the absence of chest rise and fall. So in other words, they're not breathing. They have no reflexes. They don't have any pupil reactions. Like you shine a light in their eye and it doesn't constrict, because then that's what that's talking about. They have no systolic blood pressure. So that's the pressure of blood going out of the heart. Profound cyanosis. Cyanosis is blue. That means they've turned blue. And a lot of times it'll start around the mouth. The cyanosis is because they're not getting enough oxygen, of course, because they're not breathing. Or if their temperature is lower, if it's decreased, or one thing you have to remember though is if they've been in water and you think that they have drowned and you think they're dead, you have to let them warm up before you know that they're dead, because it's warm and dead. So that's just really cold sounding, but that's what it is. Now, if you see this is where the blood is modeling on the back, and it really does this with someone who has been laying there for a little while. All their blood starts to pool into one spot, and it always you can tell by looking at their feet and their hands, because their hands and their feet are they don't have as much color to them, and they're cold because the body starts pulling the blood to the core of the body to try to be okay, to help itself. So some of the other signs of death is, of course, like an obvious mortal injury like decapitation. Say somebody shot themselves and there's brain matter everywhere. They're dead. And then the dependent lividity, which is like they talk about the blood settling. It's also called mottling. Rigor mortis, that's when they start to become stiff. And putrefaction. So putrefaction, yeah, it's the decomposition of their body. So they've started to decay already, because that can happen if they've been there for a little while. So what we have to call the medical examiner for, there are some cases that we do, and one is a DOA, so a dead on arrival, or it's also called DOS, dead on scene. Then also death without previous medical care. So if they die unexpectedly and they haven't been seeing a doctor, then that's something that we would need to call the coroner for. Sometimes he comes to other calls than that as well, or one of his deputies do, but those are ones that you have to call for the coroner. If it's suicide, if it's a violent death, say, because they're going to want to investigate. Poisonings, or if it's known or suspected. Death from an accident, say like a car accident, a shooting accident, if you think there's any criminal act. And then infant and child death also, you always have to call them. So organ donors, this is really important to me, because I actually know people that have had to have organ donation. And you want to, if you are interested in being an organ donor, you can't just put it on your driver's license. They have a little symbol on the Missouri driver's license that says you are an organ donor. But if you do not fill out the back of that, you're not a donor. So we don't, but when we see that, we don't worry about that. My sister is really funny about it, because she won't put that she's an organ. Now, she'll give organs, but she will not put that she's an organ donor on her driver's license, because she's afraid that they won't save her to save somebody else. It's not true. We don't normally pay attention to that. I do know that we have transported like pregnant women that we have kept alive just long enough until they can have the baby. We've transported them to the city that way. But that's decided by a doctor. We do what we do when we get on scene. It's always your job as an EMT to do everything that you can do to save that patient, unless they have something that says they don't want it. And organs need oxygen. So, like I said, we kept that patient alive. We kept her on a ventilator, took her to the city, and also that happens sometimes that we do that so they can be able to say goodbye to their family members. Their family members want to come and see them, because that's, one of the hardest things when you lose somebody is not getting to say goodbye. So there are different medical alert identifications. There are bracelets, there are necklaces, there are keychains, or a card indicating a DNR order, allergies, or serious medical conditions. I'm one of the world's worst. I'm diabetic and I don't wear a bracelet. But everybody that works here knows that I am. But somebody came up on scene that didn't know me, they wouldn't know that. So it is really, really important to look for those things, because sometimes people look like there is one problem with them, but it's something else. Diabetics all the time look like they are drunk, because they have that fruity smell of their breath, and they are acting funny, they're confused, they're altered, but their blood sugar could be really high or really low. Generally, if they have the fruity smell, it's because it's really high. There are also medical bracelets that have USBs in them, I guess, that has your whole medical history in it. And as I talked about, your scope of practice, what that is it outlines the care that you're able to provide. It is based on, it's defined by the state laws, and it is also, it just by your licensure, there's different things. So by the state law of your licensure, then you know what you are and are not allowed to do. So a medical director can also alter that scope of practice by doing protocols and standing orders. Like we talked about last night, our paramedics have standing orders on a lot of things. They are able to give a certain dosage of a medication and titrate, which means to build it up to a certain amount, and then over a certain amount, they have to call for orders from the ER doc or the receiving doctor, whoever they're, sometimes we're doing direct admits to the city. So that would be whoever the doctor is that's admitting them that you would contact. So standards of care. This is like the manner in which you must act or behave. What would a reasonable EMT do in this similar situation as what you're in? That's why I say follow your protocols always, and then you have that to fall back on to say, this is what this is our standard treatment. This is what any paramedic or EMT in our service would do. And they're established by the local custom, like we talked about last night. It can make a difference by your background, religion, your just all kinds of different things. It's also by the law and professional or institutional standards. For a long time, we backboarded people, and that was the standard of care for someone that was injured. But now we don't, and it took a little while to get people to understand that, but we had to prove why we don't do that anymore. You had to explain yourself, show your protocols to the different hospitals and whatnot. Textbooks can also, so what you're learning in your textbook for this class, and then of course standards that are imposed by your state. So a duty to act. What is a duty to act? A duty to act is when you are responsible to provide patient care. So when your ambulance responds to a call, of course you have a duty to act, kind of like the abandonment that we talked about last night. Once you get there, you can't leave until either someone of your skill level or above takes over your patient. And then when treatment has begun, if you start a treatment on somebody, you can't stop. And negligence is when you do not provide that standard of care. It's when you, whenever you have to meet these four elements, though, for it to be negligence. And one is you have to have a duty. So you're on a call, and you have to you're responding to a call, so then you have to get there. The breach of duty, if you don't do something to someone, if you don't, okay, say somebody's in cardiac arrest, it is not a DNR, and in your normal protocol, it would state that you would start CPR on this patient because they didn't have signs of obvious death, they're dead, yes, but they don't have rigor mortis, those kind of things to where you know that resuscitating them is not going to work. So then it would have damages then because that person died because you didn't do your duty to act. Also, causation. There has to be something that you did for sure that caused them to die. So you have to have all four of those elements to be considered negligence. Okay, and we talked about abandonment last night when we talked about the signatures at the hospitals. This is a unilateral termination of care by EMT without the patient's consent. So you quit treating them even though they didn't ask you, they still wanted you to treat them. Or making provisions for continuing care. So like when you go to the hospital, when we take a patient into an ER, we don't leave the room until the nurse comes in and is there with the patient, they get report, and then they have assumed care of that patient. Otherwise, it could be abandonment. So it could take place at a scene. Say you're at a big car accident, you walk up on somebody and you see them there. Now we do triage, of course, and you'll learn about triaging, but if somebody needs care and you just walk away and don't leave them with somebody with your license or above, then you have abandoned them. And then it happens in the emergency department, like I was explaining. You want to always obtain a signature on the patient care report. That's very, very important. The signature is them consenting to let you care for them. Of course, there are times when they can't sign, and then you have rules on how you deal with that. So assault and battery and kidnapping. So assault is unlawfully placing a person in fear of immediate bodily harm. So you can't make them think that you're going to hurt them if they don't do what you say. Like, for example, restraining somebody. There has to be a reason, and it needs to be documented, like we've talked about over and over again. If it's not documented, then it didn't happen. So you want to make sure that it's documented why you had to restrain that patient. And then battery is unlawfully touching a person. So they could charge you with battery if you cared for someone that didn't want it and that refused your care. So kidnapping, seizing, confining, abduction, or carrying away by force. So an example for us would be if we transported without consent. That is kidnapping. You cannot take somebody without their permission. And then false imprisonment is unauthorized confinement of a person. So say a patient rescinds their consent, but the EMTs don't let the patient leave the ambulance. Well, that is false imprisonment. What we have to do, we can be going down the road and a patient want out of the ambulance, we have to let them out. You have to stop. You have to let them out. Now, you want to make sure they're not in harm's way, like they're not going to get ran over by a Mack truck, but you have to let them out. So defamation. Defamation is a communication of false information that damages the reputation of the person. So in other words, like libel, that is if it's in writing. If you make a false statement on a run report, like the BFW we talked about last night. Slander is spoken. It's if you inappropriate comments are made during the conversation. So you say things about them that's not true, it's slander. So the run report should always be accurate, relevant, and factual. Leave out statements of your own that are subjective. Don't make comments in there that are not needed. Don't leave anything out that needs to be there, and never lie on a report, because like we talked about, it is a legal document. So a good Samaritan actions. There's a Good Samaritan law, and in Missouri, you should look it up. You should see what it says. I have looked it up. So it does cover, people like just the general person that would stop on a car accident. But as an EMT, you acted in good faith. To be honest, it actually refers to, it would be a civil person, not you, because you're not expecting to get compensated for taking care of that patient. And then within your scope of practice. So as an EMT, you can't do it and expect somebody to be paying you because you do it. Of course, you're getting paid as a salary. I know that's kind of confusing. You get your salary to do your job, but you're not expecting compensation from that person. And then you do not act in a grossly negligent manner. So it's just, gross negligence is, that it's a conduct where you do willful or reckless disregard for a duty of standard of care. So in other words, you say, okay, well, normally on this I would do this, but you know what, I'm not going to today because I don't want to. That's gross negligence. So another reason they have me do this lecture, records and reports. I am the keeper of all documents here. So you want to make sure that you can maintain complete records for all incidents involving your sick and your injured patients. Duh, right? Well, like we talked about in the lecture yesterday, the courts consider it that if you don't document it, it didn't happen. So even though you would say, okay, so say we used the example last night, the blood sugar. You took the blood sugar, you didn't write it down, you couldn't remember what it was, so you just didn't put it in there. And then they ask somebody else, well, what is your normal, what do you do? Because we generally check blood sugar on most every patient. But they say, well, this is our protocol, we do this, this, and this. And they said, but they didn't document it, so they couldn't have done it. Don't get yourself in a sticky situation. Incomplete or untidy reports are evidence of poor emergency medical care in the court's eyes. If you don't document good, if your spelling is wrong, that's what spell checker's for. Now, medical words, sometimes it doesn't catch, but if you use the wrong words in your narrative of your report, in your documentation, it looks bad. It looks like you don't know what you're talking about, and if you don't know what you're talking about, if you do not know grammar, then you are not competent with a patient and can't give good medical care, which is absolutely not true, but that's the way they see it. There are special mandatory requirements for reporting. We kind of talked about this some last night. A child or older person abuse, you would call the elder abuse hotline if it was an elderly person, and then the Division of Family Services, of course, and they have hotlines. You should learn those. You should find those numbers, put them in your phone because you might need them. If it is an injury during a felony, so anytime, like we said, gunshot wounds and whatnot, you have to report it. But that's because it's during a criminal act. So drug-related injuries, say somebody overdoses or whatever, if a child overdoses on their parents' pills because they did not keep them secure, that's something reportable. Attempted suicide, dog bites, certain communicable diseases, assaults, domestic violence, sexual assault or rape, exposures to infectious disease. That's also something that you have to report to us as administration, because we track that. If you don't report that you got an exposure, say you got poked with a dirty needle, you have to report that. It has to be an incident report and an exposure report, because if you don't, and something down the line, say you got poked by, this is kind of an outdated thing, but an HIV needle, and you contracted HIV, there would be that documentation to take it back to that. Therefore, we would be responsible for taking care of that. Restrained patients, you need to call for crime scenes if somebody's deceased. So now you have not only laws that you have to do, but you have ethical things that you have to remember too. Above all, you should be ethical. It's the philosophy of what is right and wrong. Their moral duties, not just necessarily legal, and then their ideal professional behavior. So you want to follow your ethics and do what is proper to do. Morality, it's a code of conduct affecting your character, your conduct, and your conscience. Bioethics it addresses the issues that arise in practice of healthcare. So just make sure that you always are, if you would have to ask yourself, ooh, did I do the right thing there? Was that wrong? And you know in your heart of hearts that it's wrong, then you shouldn't, that is kind of a guide there. You are required to evaluate and apply ethical standards, one of your own and those of the profession. So read the EMT prayer sometime. It has a lot of things in there. I will promise to act, and those kind of things. You make a commitment when you become an EMT. It allows laws and policies to guide your decision making. Granted, something may be legal, but it's not ethical. So always remember the difference between the two. So you ended up in court. Whew, that's not where you want to be. I promise. But you are a defendant, a witness or defendant. Whenever you're called to testify, you need to notify your service director and your legal counsel. Never go to court without legal counsel. And generally, we're going to know if you are taken to court before you do, because we will get the subpoena for you. But always notify us, because you should not go unprotected. When you go as a witness, Shane, our chief, he has been a professional witness for EMS cases that go to court. You want to remain neutral. You want to review the run report before you go to court. That's why your documentation is so important, because you had this call that you ran 5 years ago. You've ran thousands of calls since then. You're not going to remember everything that you did, so you're going to want to read your documentation. That's why you have to be so thorough in your documentation, so that you know. So as a defendant, you definitely have to have an attorney. As a witness, it's not so much, but we generally will talk to our counsel before we allow somebody to do that. He will kind of go over with them what they should and shouldn't say, just to keep themselves from digging in deep. So your potential defenses are statute of limitations, governmental immunity, contributory negligence. Those kind of things are things that you could have to be defending yourself against. So what discovery is, most of you probably know, but it is where both sides obtain more information, and they'll get that through interrogatories and written requests or questions, depositions, and that's oral. And attorneys are very good at twisting your word. So, and they will try to lead you. If you have good counsel, they're going to stop that. However, I get subpoenaed a lot to go for the records, but they have tried to goad me into telling them, is this normal procedure for what is in this report? And I'm like, I am not the paramedic. I did not write this report. I was not on this call. I am the keeper of records. This is how they documented it. That's all I can say. But they will say, they will twist your word any way you can and try to confuse you. So if your documentation isn't good and you have poor grammar, they're just going to discount you really fast if your spelling is incorrect, those kind of things. So just remember that. So say this case isn't settled, it'll go to court, and the damages that could be awarded might be compensatory damages. So money, they might get money. And a lot of times you will find if we are sued for something that happened, whether we believe that we are guilty or not, even if it was, it depends on what our lawyer says, but sometimes you just settle because it's cheaper to settle than to pay out all that money. But without, you don't really want to admit guilt either of anything, because if you weren't guilty, don't admit it. And then there's punitive damages. You could go to jail. So always remember to do the right thing. So any EMT that is charged with a criminal offense, you want to get a highly experienced criminal attorney. You do not, and immediately, do not talk to people without an attorney present. So kind of to review, we went over, so you have a lady that is an older woman and she's complaining of chest pain, and she holds her arm out for you to take her blood pressure. That is kind of, that's an express consent, right? Yes, express consent, because she's showing that she wants you to take care of her. I think that we pretty much covered this really good. So if you have questions, of course, you can contact Ashley. You can email me, and we will go over it. So I guess that's your lecture for Chapter 3.